morning, and thank you very much, Aurelian, for that warm welcome. It is absolutely an honor and a privilege to be here. Like Aurelian said, I'm Nick Grimmer, the managing editor of the Antitrust Law Journal. Together with our executive editor, Robbie Robertson, who unfortunately wasn't able to be here today, and our editorial board, who would be too numerous to be here today, which is chaired by Lee Greenfield, by the way, who you will hear from later this afternoon. We publish the Antitrust Law Journal. We are not a sponsor of this conference as such, but we are, of course, very, very proud that our publication is being highlighted here. So Aurelian is actually a very recent and valuable addition to our editorial board, and I'd like to thank him very, very much for inviting us here today. So around this time last year, we were very fortunate enough to be part of the inaugural GW Competition and Innovation Labs inaugural conference. Now, that conference served as the in-person and sort of discussion aspect of a symposium that we're currently in the middle of publishing right now in 2 issues called Beyond Dynamic Competition. And the common thread running through all of those articles, so many that we had to split it out into 2 issues, is dynamic competition and innovation analysis in antitrust law. Now, this year, this conference is more of an after-the-fact look at some absolutely excellent articles. Freestanding articles, though, not part of a symposium. So the only real common thread running through these is that they have been published, 5 of the 6 of them, in the Antitrust Law Journal, and that they are very high-quality scholarly articles. So I'll give some brief teasers on those articles in just a little bit before I wrap up. But first, Aurelian asked me to give just a few words about the journal. So Antitrust Law Journal is a peer-reviewed law review that's published 3 times each year. And it's as a service to the antitrust section members and for the general benefit of lawyers, economists, academics, judges, policymakers, both in the US and all around the world. I should note that even though we are part of the antitrust law section, we are very serious about maintaining our academic independence, both on the editorial side and the substantive side, maintaining that independence from the section. Our board is the one that makes the decisions, not any policymakers trying to tell us what to do. So ultimately, with all of this, our goal is actually very simple, and it is this. We aim to provide consistently top-notch thought leadership that influences the development of competition law. So, at least by the numbers, we actually really seem to be succeeding here. Indeed, the journal is, and for at least the last several decades, has been the most cited publication in federal court opinions addressing antitrust law. And not by a little bit, by a whole lot, by a factor of 3, 4, 5 times the number of cites that, for instance, the Harvard Law Review gets, or Columbia. So courts trust, courts value the journal. And this also seems to be the case with lawyers, economists, academics. But why is this? Well, 3 main reasons come to mind here. Number 1, we have incredible reach within the antitrust community. So each issue that we publish is immediately received by all antitrust section members, which is a huge but very targeted group of more than 15,000 individuals across the globe, all of whom are very interested in antitrust law. Our articles are then available on Lexis and Westlaw and cited, found and cited many times after that. So the second reason I think that that we are very trusted by the antitrust community, as we've developed a reputation for quality and influence over the years, that attracts the best authors with the best ideas to want to keep publishing with us. So it's this sort of self-perpetuating cycle of quality begets quality. And finally, I think the third reason here is that we have a very, very rigorous peer review process, both on the front end for article selection, and then after an article is selected for publication, the peer review process really then takes off with deep substantive editing. So let's talk about that for just a second. Our editorial board is where essentially all of this happens. Our editorial board comprises more than 50 of the top antitrust academics and practitioners around the world, mostly in the US, but also around the world. Each of these members has their own specific, niches and specialties that qualify them to really weigh in on how an article, can take shape and be that much more persuasive. So when we receive an article submission, we try to put it in the hands of somebody whose specialties match up with that article so that they can really dig in and say whether or not this is something that A, is accurate, B, is interesting, and C, is going to work well for our readers and further our goals as the journal. Similarly, after we've accepted an article, it will typically go through at least several rounds of serious substantive editing with one or more very experienced editors from the board. After all of that, it will be thoroughly site-checked and line-edited. That's the stuff that kind of gives me my jollies before we ultimately publish it. So I think anybody who has published with us, there's a lot of y'all in the room right now, feel free to talk to them about this experience. But I think anyone who's published with us can attest that this whole process is really incredibly beneficial for strengthening already great ideas and honing the presentation of those ideas. And in the end, I think that our process does lead to very high-quality articles that are always on the leading edge of antitrust thinking. And that, in turn, influences courts and other policymakers. And that's the end goal here. Now, one last thing that I should mention about the journal before addressing the articles that we're going to hear about today is that we strive to provide a platform for all sorts of ideas. New takes on old ideas, liberal ideas, conservative ideas, controversial ideas, you name it. All that really matters here is quality. So if we think an article is one that can help lead or at least contribute to meaningful discussion amongst the antitrust community, at the enforcement agencies, with policymakers, that's one that we're going to be very interested in. And of course, we would love to hear from any of you that have these sorts of ideas and want to write. I'll be hanging out here all day long, so please come talk to me if you have those ideas. I'd love to give you a business card and then eventually receive an article submission from you. Okay, so I'd like to close out now by just giving a very brief preview of each of the articles that we're going to hear about today. So first, Professor Eric Posner is going to discuss his article, The New Labor Antitrust. This one surveys a recent wave of empirical studies that has led to a pretty big increase in the number of claims being filed by workers against their employers. So according to his analysis, some progress has been made with respect to this sort of claim, but judicial skepticism towards these claims still does remain, but shouldn't. And then next up, we have Keith Clovers and John Jacobson, who are going to talk about their article, The Overlapping Markets Fallacy. Now here, they posit that the concept of overlapping markets, or submarkets, is neither legally nor economically permissible. Instead, they propose what they call a one market per transaction rule that they derive from Supreme Court precedent and say that's the rule we ought to actually be looking at when it comes to submarkets. Next, Professor Ayers, Hemphill, and Wickelgren are going to present Shorting Your Rivals, Negative Ownership as an Antitrust Remedy. Now, this one proposes a variety of novel but viable negative ownership remedies, and that's basically whereby the merged firm is effectively required to take a short position in its competitors. I think this is a very, very cool idea, and this is one that, I hate to editorialize too much, but I was really skeptical going into this article, and I'll be darned, they convinced me. This article really does represent to me some just thinking outside of the box, and frankly, it's one of the things that makes my job so much fun. Then we're going to have a lunch break, and after lunch, we're going to hear from 4 attorneys from White and Case, who's kind of made a big name for themselves in the reverse payment land, and they're going to be talking about that. Their article is called A Decade of FTC versus Activists. The reverse payment framework is older, but are courts wiser in applying it? So in this article, they examine a decade of jurisprudence to assess the questions that have been answered and the challenges that litigants, of course, still face in assessing claims that are brought under the reverse payment framework that the Supreme Court laid out in Activists. After that, we have Warren Edelson and Reed Showalter on their article, Captured Innovation, technology monopoly response to transformational development. Now, this is one that actually wasn't published in the Antitrust Law Journal, but which means I'm that much more interested in hearing about it today, and hopefully we can convince them to maybe publish in the Antitrust Law Journal after that. And their article examines how monopoly power warps incentives to innovate within the largest tech companies throughout history. So interested in hearing about all that. Finally, we're going to hear from Greg Worden on the competitive process standard. So his article argues that the protection of the competitive process, not promotion of consumer welfare, is actually antitrust law's governing precept. As he argues, the competitive process standard provides the logic of and gives life to the per se rule, the rule of reason, and a number of other antitrust doctrines. So I'm really looking forward to hearing from this wonderful slate of authors. So without further ado, Professor Posner, the floor is yours, sir.